A very good morning to all my dear students. Today, in this lecture of Code of Civil Procedure, we are going to discuss in detail about the written statement and also about equitable set-off and its difference with set-off. And furthermore, in this lecture, we are also going to discuss the difference between set-off and counterclaim, and also understands the concept of counterclaim as contemplated under the Code of Civil Procedure. So this is the agendas of today's lecture. Hope you all have learned from the same. But before starting with the today's lecture, I just want to recapitulate certain points. As you all are aware that we had discussed the concept of written statement in my last lecture, wherein I had discussed with you the relationship of written statement with the plaint and also with the pleadings as such. Furthermore, I had also explained you that the I had also explained to you about the time period for filing the WS and also apprised you about the object for which this WS or the written statement is to be filed. Thereafter, we had discussed about the particulars which needs to be mentioned in the written statement, wherein I had explained from Order 8 Rule 1 till Order 8 Rule 5. Thereafter, I had explained you about the doctrine of set-off, wherein I had also explained you about the conditions for filing a set-off in a court of law, which is also a cross-claim to that of plaint filed by the plaintiff. Furthermore, we had also discussed with you in my last lecture regarding the conditions or also about the effect of set-off as contemplated under the Code of Civil Procedure, meaning thereby what would be the effect on the set-off filed by the defendant in case the plaintiff suits dismissed by the court of law, whether the set-off would be maintainable or not. To this, I had given you an answer that yes, the same is being maintainable because it would be treated as cross-claim. Now, I would like to explain the same in the light of a new concept, that is equitable set-off, which I am going to deal with the same in today's lecture. Now let's start with this same. Equitable set-off, as you all are aware, that legal set-off is given under Order 8, Rule 6 of CPC, but they, but it was allowed by the Court of Common Law in England, and it was allowed, and it is always in respect of a certain sum of money. Provisions of Rule 6 are not exhaustive, as they are only deals with the ascertained sum of money to be claimed by the defendant from the plaintiff. As such, in addition to legal set-off, equitable set-off is allowed by the courts of equity in England. It may be claimed for an unascertained sum of money. So, from this, we may say that this is one of the difference between the legal set-off and equitable set-off. It may be claimed for an ascertained sum of money provided that both the cross demands arise out of one and the same transaction or are so interconnected in this nature and circumstances that they can be looked upon as part of the transaction. In such a case, it would be inequitable to derive the defendant to separate suit. So from this, we may infer that the equitable set-off can be claimed for unascertained sum of money. Is there any provision regarding equitable set-off? Answer is yes. Order 20, Rule 19, Clause 3 of the Code recognizes an equitable set-off. Next. Whether we can give an example? Yes, we can give an example where A sues B to recover rupees 50,000 under a contract to B. B can claim set-off towards damages sustained by him due to the breach of the same contract by A. So this is a case of equitable set-off. Furthermore, I can give you one more example for better understanding of this concept. In a suit by washerman for his wages, the defendant employer may set off the price of the clothes lost by the plaintiff. Now, I would like to explain you about the difference between the legal and equitable set-off. As I had already apprised you in my last slide that legal set-off must be for a certain sum of money, whereas equitable set-off may be for an unascertained sum of money. Second, legal set-off can be claimed of as right and the court is bound to entertain and adjudicate upon it. Whereas equitable set-off, on the other hand, cannot be claimed as of right, and the court has the discretion to refuse to adjudicate upon it. So from this, we may infer that legal set-off is a statutory provision and can be claimed as a matter of right, but equitable set-off cannot be, because it is not a right inherent in defendants in a suit. Now, we will go further. The third difference between the legal and the equitable set-off is that in a legal set-off, it is not necessary that the cross demand arise out of the same transaction. Whereas equitable set-off, on the other hand, cannot be claimed as of right, and the court has discretion to refuse to adjudicate upon it. In a legal set-off, it is necessary that the amount claimed as set-off must be legally recoverable and must not be time-barred. But in the case of equitable set-off, a claim of equitable set-off may be allowed even if it is time-barred, when there is a fiduciary relationship between the parties. So from this, we may infer that in case of the legal set-off, you cannot claim the time-barred debt, meaning thereby defendant does not have the right to claim the time barred debt from the plaintiff by way of equitable in a legal set-off. Whereas this is possible in the case of equitable set-off, provided the same is under the fiduciary relationship. What do you mean by fiduciary relationship? It's a relationship of trust and good faith. Next. So this is all about the concept of equitable set-off and its difference with legal set-off. Now I would like to explain another concept which is also very important from the point of view of a law student. And that concept is the concept of counterclaim. It is a claim made by the defendant in a suit against the plaintiff. So it is also a claim made by the defendant in a suit against the plaintiff. Furthermore, it is a claim independent and separable from the plaintiff's claim, which can be enforced as a cross action. So this is a cross action as contemplated under the Code of Civil Procedure. It is a cause of action in favor of the defendant and against the plaintiff. So in this, there is a cause of action which lies in favor of the, or which tilts in favor of the defendant and against the plaintiff. This remedy may be an addition to the defendant's right to plead set-off. So this is in addition to the claim of set-off. It may be set up only in respect of the claim for which the defendant can file a separate suit. So, to prevent the multiplicity of suit, this particular remedy given under the law, as I had already explained to you, it is also substantially a cross action. Now we will move further. Is there any provision in the original Code of Civil Procedure 1908 regarding counterclaim? Answer is no. It was added in the year 1976 by CPC Amendment Act. What is the position before 1976 in the case of Lakshmi Das versus Nana Bhai, EIR 1964, Supreme Court? It was held by the court that even though it was not given a statutory status, but still it could be claimed in the money suit. So, by virtue of judicial jurisprudence, this particular doctrine was evolved by the court and used by the court in the case of money suits. Now, to give it a statutory recognition, the Law Commission recommended this particular expression and doctrine to be inserted in the Code of Civil Procedure in the year 1976, and thereby to avoid multiplicity of proceedings. Right to the defendant to raise a plea of set-off in addition to the counterclaim in the same suit. So in this same suit, the defendant may, along with the set-off, can also file counterclaim as well. Now, what would be the nature and scope of counterclaim? Rule 6A to Rule 6G of Order 8 were added in respect of counterclaim. In this, the defendant may be set up by way of counterclaim against the claim of the plaintiff either before or after the filing of the suit, but before the defendant has delivered his defense or before the time fixed for delivery of his defense has expired, files counterclaim. So from this, we may infer that till he has not filed his WS, he has the right to file the counterclaim as well. But after the expiry of the filing of the WS, the same cannot be filed. But recently, in the year 2020, Supreme Court has evolved that in certain circumstances, this counterclaim can also be filed even after the filing of the WS. Such counterclaim must not exceed the pecuniary limits of the jurisdiction of the court. So from this, we may infer that it may exceed the plaintiff's claim, but it cannot exceed in any circumstance the pecuniary limits of the jurisdiction of the court. Next, I can give you an illustration over here regarding counterclaim. When A has a claim of any kind against B and brings an action to enforce that claim, and B has a cross claim of any kind against A, which by the law he is entitled to raise and have disposed of in the action brought by A, then B is said to have a counterclaim. What would be the effect of counterclaim? Counterclaim has the effect of cross suit, and the court can pronounce a final judgment both on the original claim and as well as on the counterclaim. The counterclaim of the defendant will be treated as a plaint, and the plaintiff has the right to file the WS in answer to the counterclaim of the defendant. So, in this, the defendant's counterclaim would become the plaint, and the plaintiff has to file the WS, thereby becomes the defendant in the counterclaim. Further, the effect of the counterclaim is that even if the suit of the plaintiff is stayed, discontinued, and dismissed or withdrawn, the counterclaim will be decided on merits. This is like the concept of set-off, which we have read earlier. Next, what is the distinction between set-off and counterclaim? Set-off is a statutory defense to plaintiff's action, whereas counterclaim is substantially a cross action. Set-off must be for an ascertained sum of money, or it must arise out of the same transaction. A counterclaim, on the other hand, need not arise out of the same transaction. Set-off is a ground of defense to the plaintiff's action. In other words, the former is a ground of defense, a shield which, if established, would afford an answer to the plaintiff's claims in toto or pro tanto. The latter is a weapon of offense, a sword which enables the defendant to enforce the claim against the plaintiff effectively as an independent action. Next, in the case of legal set-off, the amount must be recoverable at the date of the suit, while in the case of counterclaim, the amount must be recoverable at the date of the WS. When the defendant demands in a plaintiff suit an amount below or up to the suit claim, it is set off, but when it is for the larger amount, the claim for excess amount is really a counterclaim. So this is all about the difference between the set off and counterclaim. And also, this is all about today's lecture. Hope you have enjoyed as well as learned a lot from it. Before parting with the today's lecture, I would apprise you about the new topic which I am going to take in my next lecture. The next lecture of mine would be on appearance and non-appearance of parties regarding its consequences and non-consequences. And the same has been dealt under Order 9 CPC. Hope you have enjoyed a lot. Stay home, stay safe, and be positive during these COVID days. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe. Once again, thank you very much.